Kentucky adopted the Uniform Residential Landlord and Tenant Act in 1984, and it's found in Kentucky Revised Statutes, Chapter 383. This gives the state a solid statutory framework for habitability, but there's a major catch that every Kentucky landlord needs to understand. Here's the catch. The Kentucky URLTA only applies to certain counties and cities. Specifically, it applies to counties containing a city of the first class or a consolidated local government, which means Louisville and Jefferson County, and any other county or city that has chosen to adopt it by local ordinance. For the rest of Kentucky, including large parts of the state's rural areas, the URLTA does not apply, and landlord-tenant relationships are governed by common law and the terms of the lease. This means that depending on where your property is located, your legal obligations could be significantly different from a landlord in the next county over. That's a critical distinction that a lot of Kentucky landlords miss. In areas where the URLTA applies, landlords have clear obligations under Section 383.595. You must comply with all applicable building and housing codes materially affecting health and safety. You must make all repairs necessary to keep the premises in a fit and habitable condition, maintain electrical, plumbing, sanitary, heating, ventilation, and air conditioning systems in good working order, provide running water and reasonable amounts of hot water, supply trash receptacles and arrange for removal where applicable, keep common areas safe and clean, and provide working smoke detectors. Kentucky's climate creates year-round maintenance demands. Winters in the eastern and central parts of the state can be harsh, making heating a critical issue. Summers bring heat and humidity that make air conditioning important, and if your unit was rented with AC, you're responsible for maintaining it. The state's susceptibility to severe thunderstorms and occasional tornadoes also means that structural integrity and weatherproofing deserve ongoing attention. In URLTA areas, the tenant remedy process is structured. Tenants must give written notice of the habitability issue. The landlord has 14 days to make the repair for non-emergency conditions. If the condition involves a material threat to health and safety, the timeline is compressed, and the landlord must act promptly. If the landlord fails to act, tenants in URLTA jurisdictions have several remedies. They can pursue damages in court. They can seek rent abatement. They can obtain a court order requiring the repair. And if the non-compliance is material, they can terminate the rental agreement after providing proper notice. Now, in areas where the URLTA does not apply, the landscape is different. Landlords are still bound by the implied warranty of habitability, which Kentucky courts have recognized through case law. The basic standard still requires you to provide a dwelling that is fit for human habitation. But the specific statutory remedies available under the URLTA, like the structured notice and cure process, don't exist in non-URLTA areas. Tenants in those areas must rely on common law remedies, which typically means filing a lawsuit for breach of warranty, seeking damages in court, or arguing constructive eviction. This dual system creates a situation where Kentucky landlords genuinely need to know which framework applies to their property. If you're in Louisville or another jurisdiction that has adopted the URLTA, you follow the statute. If you're in a non-URLTA area, you follow common law principles, which provide less detailed guidance but still require you to maintain habitable housing. Kentucky does not have a statutory repair and deduct remedy, regardless of whether the URLTA applies. Tenants cannot make repairs and deduct the cost from rent. They need to pursue formal legal remedies through the courts. The state's anti-retaliation protections apply in URLTA jurisdictions under Section 383.705. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a habitability complaint or exercising their legal rights. In non-URLTA areas, retaliation protections are more limited and depend on common law principles. For the complete guide to Kentucky habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay current on every state.